guys. Hello. So, this video is a bit of a continuation or bonus content to the last video I uploaded on YouTube. My hair's looking a little flat. It's okay. So I wanted to read some of the court documents, or at least one of the court documents, that was submitted to the court to try to stay Lisa Montgomery's execution. If you haven't seen that video on YouTube, check it out. Should be the most recent one that I uploaded. And it has all kinds of background information about the case. There's also some kind of commotion happening upstairs. I'm hoping that it's over now. So, this court document starts as Lisa Montgomery versus William Barr. A memorandum of law in support of motion for temporary restraining order and preliminary injunction. Plaintiff Lisa Montgomery respectfully submits this memorandum of law in support of her request for a temporary restraining order and preliminary injunction. Introduction. Plaintiff Lisa Montgomery is the only woman on federal death row and the first woman to face federal execution in nearly 70 years. On October 16, 2020, defendant Barr announced with no notice to Montgomery's lawyer that he had scheduled her execution for December 8, 2020. At all times between October 16th and the date of this filing, the COVID-19 pandemic has threatened the health and well-being of millions of people, including those involved in the case of Mrs. Montgomery. Infection rates are now at an all-time high. 3 days after the execution date was set, Mrs. Montgomery's lead lawyers, Kelly Henry and Amy Harwell, traveled to Carswell, Texas to meet with Mrs. Montgomery. Mrs. Montgomery has several mental disabilities that frequently cause her to lose touch with reality. The symptoms of her mental illness are particularly severe in times of stress. When Henry and Harwell visited her at the Carswell unit, they discovered that Mrs. Montgomery's mental health had already deteriorated. She was particularly distraught about the conditions of her confinement. She had been placed in a suicide cell, and her underwear had been taken away. As a victim of repeated rape, incest, and child sex trafficking, the loss of her underwear was particularly dramatic. Henry and Harwell spent hours trying to calm her down, explaining the status of her case and ascertaining her current mental status. Mrs. Montgomery's mental health and the extent to which she is able to grasp what is happening to her lies at the core of her efforts to obtain a reprieve and a commutation of her sentence to life imprisonment. For this reason, among others, it is vital that counsel be able to meet with Mrs. Montgomery in person to evaluate her mental status. This is particularly vital since as a result of the pandemic, the mental health experts who have evaluated Mrs. Montgomery in the past are unable to travel to the prison. positive result on November 11th. Both contacted their physicians, who directed them to rest and quarantine. Harwell was forced to cancel a trip to Carswell. Neither can travel to visit Mrs. Montgomery between now and the filing deadline for clemency application. Moreover, both Harwell and Henry are virtually bedridden. They both have debilitating fatigue that prevents them from working on Mrs. Montgomery's clemency application. They have a range of other symptoms as well, including headaches, chills, sweats, gastrointestinal distress, inability to focus, and impaired thinking and judgment. Defendant Barr's setting of Mrs. Montgomery's execution date during the height of the pandemic has therefore interfered with Mrs. Montgomery's statutory right to counsel to assist her in the filing of her clemency application. It has also prevented her from participating in the clemency process, as she relies on her attorneys to present a comprehensive petition for commutation. Neither her attorneys nor the mental health experts who are familiar with her mental health are able to visit her to ascertain her mental status. Injunctive relief is therefore essential to preserve Mrs. Montgomery's rights to access a clemency proceeding under conditions that allow her untrammeled access to counsel and expert assistance. As a person with profound mental illness, Mrs. Montgomery requires the assistance and advice of counsel, and as a person with a history of extreme trauma by overwhelming sexual violence, she requires careful and compassionate some minimal procedural safeguards apply to clemency proceedings. Mrs. Montgomery will succeed on the merits. The Supreme Court in Harbison underscored the vital role of counsel in the clemency process. The court held that death-sentenced prisoners are entitled to representation by counsel in clemency proceedings, and that this representation should be carried out by lawyers who represented the prisoner in federal habeas proceedings. Although Harbison involved the application of federal statute, the court's interpretation of Congress's intent was intertwined with its conclusion that clemency is the historic remedy for preventing miscarriages of justice, where judicial process has been exhausted. Indeed, the court rejected the government's contention that clemency proceedings are, quote, a matter of grace entirely distinct from judicial proceedings, emphasizing that clemency is the fail-safe in our criminal justice system. Reversal of an erroneous conviction on appeals or habeas, or the pardoning of an innocent condemnee through executive clemency, demonstrates not the failure of the system, but its success. Those devices are part and parcel of the multiple assurances that are applied before a death sentence is carried out. And that was a quote from Scalia. Yet Mrs. Montgomery's lawyers cannot represent her because they are seriously ill, through no fault of their own. On the contrary, they are sick because defendant Barr recklessly scheduled Mrs. Montgomery's execution in the middle of the COVID-19 pandemic. But for Barr's action, counsel would not have been stricken with the disease that is ravaging the country. But the pandemic affects more than counsel. Because of COVID-19, the experts familiar with her case cannot assess her mental state, and therefore cannot participate in the clemency process. The Harbison court implicitly recognized that meaningful access to clemency is an essential prerequisite to the exercise of a prisoner's liberty interest in the clemency process. Yet, without the guiding hand of counsel, prisoners are effectively prevented from accessing the federal clemency process. Congress sought to ensure that condemned men and women would not be abandoned by their counsel at the last moment and left to navigate the sometimes labyrinthian clemency process from their jail cells. And this was because of the passing of 18 U.S.C. 3599. These concerns are especially compelling in the case of prisoners such as Mrs. Montgomery, who is profoundly mentally ill and incapable of advocating for herself. 2. Mrs. Montgomery will suffer irreparable injury if the injunction is not granted. Quote, perhaps the single most important prerequisite for the issuance of a preliminary injunction is a demonstration that if it is not granted, the applicant is likely to suffer irreparable harm before a decision on the merits can be rendered. It is beyond cavil that Mrs. Montgomery will suffer irreparable injury if the requested restraining order is not entered by this court, for she will be deprived of any meaningful opportunity for review of her clemency request. The remedy that provides a final fail-safe for the death sentence prisoner. If this court does not exercise its equitable powers to enjoin the defendants from taking adverse action on her request for reprieve, it will allow defendants asserted. It is certain